Present the appellant in this matter, the estate of Gloria Cooper. I'd like to reserve 3 minutes for my rebuttal.
All right, you got it.
Thank you. This is a contract case. The contract at issue is a settlement agreement. The history of the settlement agreement is there was a trial upcoming on a premises liability claim against one of the appellees. On the eve of trial, the settlement agreement was worked out where a $500,000 final judgment would be entered against the appellee. In exchange, there would be a settlement agreement which would allow for the appellee to pay certain amounts. If those payments were made, then they could get a satisfaction of the final judgment for less than the face value. The terms of the contract are pretty straightforward. You need to make your payments by the 9th of each month. If you don't, we give you a cure notice, written notice, gives you 10 days to cure, favorable to the party. But if you don't cure during that time period, the contract also said that you would be in default. We could terminate the agreement and use the past payments received against the final judgment and seek to enforce the final judgment. This was agreed to and the contract was entered into. Under the contract, time was of the essence for the payments because it was the only thing that at that time the appellee Caribe Health Center had to do. They had to make payments by the 9th of the month, if not cure, and make those payments in a timely manner. It's undisputed there was a material breach of this contract. The material breach occurred in June 2018. It was supposed to be the 4th payment. That 4th payment was not made, and we'll discuss that in the future. But the bottom line is, as a result of that material breach, the appellant elected to terminate the contract, terminate the agreement. In doing so, there was no more settlement agreement to be enforced, no more settlement agreement for any payments to be paid under. The appellee argued that the settlement agreement was still in full force and effect when they attempted to make what they called their final payment 6 months later in December of 2018. In enforcing the settlement agreement against the appellant, the trial court found that the appellant had accepted late payments from the inception of the contract. Therefore, the tardiness of the June 2018 payment was not a material breach of the settlement agreement. So the trial court waived the June material breach and enforced the settlement agreement. It's our position, based upon the undisputed evidence and the application of black letter contract law, that there was no waiving of the timing provisions of the settlement agreement as to payments, and therefore the trial court's order enforcing the settlement agreement should be reversed and we be allowed to proceed against what was ultimately entered as an amended final judgment. Going to the undisputed facts, I'm going to talk about the payments. The first payment was supposed to be March 9th. And that was a Friday. I believe it was made on a Monday. 3 days late, but communications were there because the settlement agreement had just been reached. Reasonable forbearance on the part of the appellant. We accepted the payment without putting out a cure letter or trying to do anything of that nature. That did not waive the timing requirements of the settlement agreement.
Let me ask you, Mr. Seifert, in connection with that and with the April payment also, which was 2 days late, did you initially reach out to the appellee, or did they say, oh, hey, we know we're late, we just need a couple days?
We initiated contact. Okay. Within the record, we initiated the contact to make sure payment was forthcoming. And in fact, the agreement had just been reached. So we had talked and they said, listen, it's a Friday. We're going to get the money to you on a Monday of the time of our first payment. So we received assurances, which led us not to go ahead and issue any cure letter at that point.
So with respect to all of those, the March, the April, the May, you were always the one who said, hey, guys, it's the 9th. Are we getting our check? So you were always the ones, you always initiated the contact?
Yes, Your Honor. We were following up on the settlement agreement. My client was a paralegal, so she was very fastidious about that and wanted to make sure that everything was being followed. We did engage in reasonable forbearance, which I think is an important legal concept, in not sending out a cure letter. And I think the reality is, even if we'd sent a cure letter, they would have cured within that time period because they would have made those payments within 10 days of even if we sent it out on the exact date. So at that point in time, I think the argument is we did not waive any payment provisions under the contract. The third payment was not paid in a timely manner. We did issue a cure period letter, 10-day letter. It was not paid within the 10 days. We reached out did not receive any assurances. We declared a default. And the only way to cure it, because we sought to keep the settlement agreement in place, was that we wanted to have the guarantor of the settlement agreement, Anna Dominguez, who is the president and sole shareholder of Caribe Health, added as a defendant to the final judgment. They agreed to this. A stipulation was entered by the parties. Trial court entered an amended final judgment naming not only Caribe, but Anna Dominguez as defendants. We wanted to make sure we enforced the settlement agreement. We didn't want to default right away. We were trying to keep the settlement agreement alive, and we also wanted to let them know that we were serious about the enforcement mechanisms under the settlement agreement.
Let me also stop you right there, because I think throughout the briefs, apart from the fact of what you just explained about the significance of adding her as personally liable under the amended judgment, that did not have any effect on the terms of the settlement agreement itself, correct?
Correct, Your Honor. We had the ability to declare a default once the 10-day cure period had not been satisfied. That was our election under paragraph 6 of the settlement agreement. Based upon the ongoing communication with the appellees at that time, we elected to go ahead and amend the final judgment and keep the settlement agreement in place.
Well, I have a question too, because wasn't the timeliness of the late payments required to have been made before there was an amendment to add Anna Dominguez to the judgment?
Your Honor, we did make the payments contingent upon the amendment, but we wanted to be assured of our payments first and foremost because it was the money we sought under the settlement agreement. Did I answer your question adequately?
Well, I think I asked the opposite. I think, wasn't there an argument that Ms. Dominguez could not be added if the payments were not timely? But the opposite question is, if the payments were untimely and they were accepted untimely, then shouldn't that have been raised by the other side before they agreed you could add Anna Dominguez?
Yes, Your Honor.
It's to adding her.
I think the argument is if everything had been timely and there was no default and no problem, Ms. Dominguez should not have been added as a defendant. But because they admitted that they were untimely, a default, and there was no defense to the default, the only way to keep the settlement agreement intact was to accede to our request of adding Ms. Dominguez. So by adding her, it was confirmation with no objection that there had been a default under the settlement agreement already.
Where does the argument come from that you accepted untimely payments? That's an argument that was waived, it seems to me, once this lady was added.
Yes, Your Honor, we did not. We never accepted any untimely payments as our position.
Well, I mean, that's affirmation.
Yes, Your Honor.
I'm going to see what they have to say. Thank you.
Yes, Your Honor. And to that point, those are the last payments received under the settlement agreement. There were only 3 payments received while the settlement agreement was in full force and effect. A payment that was 3 days late, a payment that was 2 days late, and then the third payment we just discussed. So we move on to the payment at issue where there was a material breach, the June payment. The June payment was not made in a timely manner. This is the second time it hasn't happened. We sent out another cure letter, no communication during the cure letter time period, 10 days pass or not paid. Once the cure letter expires, and the record shows this, we sent a good faith letter to the defendants, the appellees in this matter, simply asking if your client's still going to be bound by the settlement agreement or if they've decided they're not going to make any payments anymore. And it enclosed, please advise me of your client's decision. This is in the record 109. The response was at 110. Same date, I'll be in touch with them. They seem to have, quote, forgotten, unquote, the deadlines. I will be in touch with them today. That was the last we heard on it. 5 days elapsed all the way up to the 26th at that point in time of June without any assurances or promises of payment. My client elected, as was her right, to declare a default and a material breach of the settlement agreement. She terminated it. We sent out discovery and aid of execution, both interrogatories and requests for production. And on June 27, 2018, we sent a termination letter letting them know the settlement agreement had been terminated. It was breached, no longer in effect. Also following the terms of the settlement agreement, which had stated that if there was a breach, we could apply all past payments to the outstanding judgment, and any future payments would be received not as payments under a settlement agreement, which was no longer in effect, but just as credits against the amended final judgment. No objection to this notice. The only thing we received was another $10,000 payment with a request, can I not respond to the discovery requests? Confirmation that they understood the termination of the agreement and that they were the cause of the termination of the agreement. In order to be clear, August 10th, 2018, we sent an accounting letter. It says we received $40,000 to date, which would have been $30,000 money received while the settlement agreement was in effect, $10,000 after the settlement agreement had been breached. We indicated for accounting purposes, all of these funds were now being credited against the amended final judgment. No objection. There were additional payments after that we received, another 3 payments, and for each of those payments, document in the record in the briefs. We received them, immediately notified them they were being credited against the amended final judgment. No objection, no response. We sent another accounting letter. $70,000 had been collected at this point. Let them know again, all funds received to date credited against the amended final judgment. No objection, no response. We received 2 more additional payments against the amended final judgment, each one of them receiving the same indication that each one was being credited against the amended final judgment. No objection, no response. Finally, and sometimes predictably in these cases, whenever the amount tendered is going to reach the amount of the original agreement, there was an attempt as a payment in full. We received notification that they would provide us with the final payment of $10,000, would deposit it, and they hope to receive a release from judgment and dismissal shortly. We indicated in numerous correspondence that the settlement agreement had been terminated. There was no settlement agreement in place. We're now in December 2018. The settlement agreement had been terminated for 6 months. There was no settlement agreement to reactivate, revive, do anything with. We made it very clear in our correspondence. More importantly, we did not accept the payment. We did not negotiate it. We did not deposit it. So we rejected the payment with its conditional language. The only 3 payments made under the settlement agreement were not untimely. We did not waive the time requirements in accepting them. We enforced the settlement agreement at all points in time where it was in effect, which was only for the first 3 payments. We properly terminated the settlement agreement with notice. Thereafter, we notified that each payment we received would be credited against the amended final judgment only for 6 months, and for every piece of information, notice we provided, no objection, no response. So based upon that type of uninterrupted acceptance, it's called ratification. Even whatever you're arguing, you've already ratified the agreement has been terminated, and you've accepted that all of your payments have been credited against the amended final judgment. If you had any dispute, you should have stopped your payments, filed a notice, or called it up for hearing at any of those points. So in conclusion, based upon the undisputed evidence in the record, and there was no live testimony at the hearing, so this court's review is de novo, black letter law. We would argue that the court's order enforcing the settlement agreement should be reversed, and we should be permitted to continue seeking enforcement of the amended final judgment. And I'll reserve whatever additional time I have for rebuttal.
Well, I think you asked for 3 minutes, but technically you could ask for up to 5. What, you want to go with the 5?
I'll stick with the 3, Your Honor. I think this is a pretty cut and dry.
All right, thank you. Mr. Penn, I believe you have 20 minutes. Begin. You're on mute. Mute. You got it. Thank you.
May it please the court. Mark Penna for the appellee, Your Honors. First issue is all payments from the inception of this agreement were untimely. And what ended up happening—
Could you define untimely? Was there a grace period?
The settlement agreement in question, first of all, does not have a time is of the essence language. It just doesn't. It could have, but it doesn't.
Well, Mr. Penna, let me stop you there, because I agree that the settlement agreement does not specifically say time is of the essence. But when you look at paragraph 3, it says the plaintiff agrees to accept the sum of $100,000 in full satisfaction of the final judgment only if the following payments are timely made as set forth below. And then when you look at paragraph 4, it says each payment shall be delivered on or before the 9th day of each month. So even though it does not have a time is of the essence provision, your client was still contractually obligated to make those payments by those dates, correct?
Absolutely correct, and she did not. Those,
Well, how, I mean, even, it seems to me, why isn't that language sufficient to put your client on notice that if those payments aren't made by those dates, that's a material breach?
the issue, Judge, and it's notice, and the appellee's argument is that the lower court found under contract principles that the course of conduct concept, prior dealings concept, and the overall universe of this argument led the lower court and should have this court find that the parties, by their conduct, the appellant, by their conduct, ratified the original agreement. As you said, Judge, this contract said the March payment was due March 9th, shall. It wasn't made on March 9th. So, and that's
Right,
the case.
and on the 9th, the appellant said, okay, where's the payment?
Oh,
And,
okay.
and in reasonable forbearance, your client said, well, it's Friday, we'll give us till Monday. And in reasonable forbearance, they said, okay, you have until Monday. So we've got, what, a 3-day difference.
And then in the April payment, it was also not made.
Right, and there was a 2-day difference, right? So well within the 10-day grace period.
And then the May payment was also late.
Now, right, it was 22 days late. And
Yeah.
that's when the appellant said, okay, we have a problem here. Are you gonna follow the settlement agreement or not?
No, I think that was in June, Judge, with all due respect. I think that,
I thought it was after the May payment that your client was added as to the amended final judgment.
the amended final judgment was June 1, but
Right,
the correspondence, the unilateral termination of the settlement agreement came in June
right.
after June 1st, and the lower court found that given the conduct of the parties, basically that the debtor from the beginning completely ignored the settlement agreement as to that term, but he found that it wasn't material because of as to the other terms of the settlement agreement. This is a contracts case, contract principles, materiality, and prejudice in course of dealing. We have a contract that calls for $100,000 to be made in monthly installments and to be done before March 9th of 2019. The court found that the debtor paid because, as a matter of law, the last payment was made. It was the only one sent back, but it was made. So the court found that this debtor paid $100,000 and paid it 2 months prior to the deadline. And then heard the arguments of counsel. As Mr. Seifert said, there are no facts in dispute. There was no testimony. So the court just heard from the argument saying, in the end, we have a settlement agreement, not a judgment. This is not an action under our collection statute for a judgment. This is an agreement. The agreement has terms. We're going to say the terms are in granite. They weren't followed. The case I cited on that, the Kelly case, sets up when that happens. And that is what discussed the issue of course of dealings. And what does that deal with? That deals with what's in the mind of the debtor. What's in the mind of the debtor, not the creditor. So the debtor says in March, yeah, I had a payment due on the 9th. Well, what'd you do? I ignored it. I didn't make it. What happened? Nothing. What happened in April? Had a payment due on the 9th. What'd you do? I ignored it. I didn't do it till later. What happened? Nothing. Same thing happened in April.
Well, did nothing happen or did something happen? You talked a lot about the actions and the words, but don't the words matter too? Didn't the opposing party say this is unacceptable, or hey, where's the payment? It's past due.
Well,
So something happened.
I don't know if the judge, I think there was in March, and I don't think that happened in April and May. The key point of the brief was what happened in June June came, nothing came. Hey, what are you guys going to do? Yes, more words. There's no doubt that the lower court chose.
So you're saying they would have had to reject the late payments in order to retain their right under the agreement to give notice, and upon failure to cure during the notice period, take actions that were their right under the contract.
Because then that would have been the only evidence. First of all, there's absolutely no evidence that specifically the debtor agreed that any future payments were going to be posted to anything other than the first and only agreement. There's no evidence.
Where did the debtor have to agree?
In basic contract law.
No, basic contract law is you have a contract and you read what it says. That's the starting principle with the contract. And in paragraph 6 of the contract, if no payment is received from the defendant within the cure period, plaintiff at its option can declare a default under this agreement, not under certain circumstances, not must do so to preserve its rights, but at its option can declare a default under this agreement and shall have the unfettered ability to seek full execution of the final judgment, with all payments received to date being credited solely, et cetera, et cetera. So where does that require the debtor to agree to that? And to the extent that the debtor is required to agree to that, didn't the debtor agree to that when they signed the settlement agreement authorizing the plaintiff to do that?
Judge, is the appellee's position that the debtor never agreed for any future payments to be made towards anything other than the $100,000 settlement agreement.
I understand that that's your position, and I'm asking you what says that the debtor had to agree before that could be done? When the plaintiff could do that at its option and in its had unfettered ability pursuant to the plain language of the settlement agreement.
And as we argued in the circuit court, the creditor waived its right to that enforcement by its conduct of constantly accepting money in breach of the specific terms of the agreement, month after month after month. And what the lower court found was, yes, there were more words in June, but in the end, we have an agreement for $100,000 that was paid. It was
You had an agreement for $500,000 too. $500,000.
No, we have a judgment for $500,000.
Yeah, the agreement was, I get to execute on that judgment if you do not do X, Y, and Z. Your client agreed to that.
Which was to pay $100,000 prior to March of 2019.
Which was to pay installments on or before the 9th of the month, beginning on March 9th.
And what the lower court found was she paid installments at some point ahead of schedule, which is additional consideration as a matter of law. Time value money is a thing of value, which means a consideration. So the court found that she had a $100,000 obligation by March of 2019 that she paid off by December in monthly installments. And obviously the court did not state that they were timely made. They couldn't. We all agree they weren't timely made. What the court found under the Kelly case was that a course of conduct was created between the parties because in the stream of commerce, we want to encourage payments. Payments are a good thing. The appellant kept accepting the benefit of the payments. Then says,
maybe I might be reading the Kelly case differently from you, because the part that I'm reading, and I may be reading it the wrong way. Here, Kelly Tractor accepted only 2 late payments on a 12-month lease. Thereafter, the record is undisputed that Kelly Tractor contacted Appleese and notified them that they were in arrears on their March and April payments. Under these facts, we hold that the trial court erred when it found that Kelly Tractor had not acted in good faith in exercising its rights to replevy the tractor without notice.
Your Honor, I agree with that. But here's the reason I cited the Kelly case it's not a waiver case. And I'll cite on the page 263/264. The court stated, but waiver is not the issue before us. The issue is the right of the buyer creditor to rely upon the prior dealings that had taken place and the buyer's right to be notified of a modification. What the lower court found and what this court should find is, from the beginning, the course of conduct was nothing's going to happen and you can keep your agreement, and it was ratified constantly, even if you're late, as long as you make a monthly payment. And when that happened, the court took, the circuit court took materiality, prejudice. There's no prejudice to the appellant. They were supposed to get $100,000 under this agreement by March of 2019. They got $100,000 2 months earlier. So there's no doubt the payments weren't made, but from the beginning, that's the course of conduct. And the course of conduct in the debtor's mind is, I can do this so long as I make a payment monthly, even if it's late. And it's true, because that's what happened in March and April and May. What Mr. Seifert arguing is that everything changed in June. But the lower court found everything that changed in June was more words. Yes, he should have stopped and filed either under the collection statute, should have filed an action under the contract. But the biggest point of the biggest variable for the circuit court judge was they kept accepting payments, future payments. Forget about the past payments of the June split. Kept accepting payments to put her ahead of schedule. If instead,
well, let me ask you this: you kept accepting payments to put her ahead of schedule, but there was no schedule anymore.
In the debtor's mind, in the course of dealings, there certainly was.
Well, there was no. Let me ask you this: make sure I'm talking about the correct chronology here. The June payment was the payment that was declared a default, right?
Well,
declared. I'm not saying you have to concede it was a default.
The
right?
June payment. Well, I argue that all of them were declared a default. They were all late. But the June,
there was no. Let me ask you this: why was there a schedule anymore to conform to? When at the point at which the default was declared, if under the contract, what schedule had to be adhered to? You said they kept accepting late payments. They kept accepting payments in advance. Well, of course, wouldn't it also have been something reasonable for them to infer that, yeah, well, they're trying to get towards 500,000, you know, they know that they owe the whole thing. So, you know, it's not an early payment. It's just payment on what it's just towards the payment you owe, which is a $500,000 judgment.
Court found, and this court should find, that they couldn't keep any monies towards 500,000, without her express consent, offer and acceptance. She never said, okay. As Mr. Seifert stated, he was ignored. They were ignored. Now, obviously, the better practice would have been for her counsel at the time to send an objection letter or something. But the law under Kelly and under Free is they should have stopped accepting payments. We foreclosure defense attorneys hear it all the time. Not all the time, about half the time. And that's the point.
Let me ask you a question. When Ms. Dominguez was added, is your position that did not activate the $500,000 amount?
No, absolutely not. When she was added,
Why would she be legally added to the 100,000?
Well, remember,
100,000. Wasn't the whole point to add her in and make it 500,000?
she was added in June 1. The
And
breach
why
after
did it
that
change the principle?
was after that.
Yeah, but why would that not change the principle at that point?
It didn't modify the agreement.
It changed in May.
It
When did it change to 500,000 in your view?
Excuse me, Judge?
When did it change to 500,000? You're arguing over 100,000 versus 500,000, correct?
Yes, it never changed to 500,000 in our view.
Okay,
And in
what's your view of their position that it changed on what date?
June 27th.
All right.
And the record also shows that a payment was made and accepted on June 27th. So again, in the Kelly case, we look at in the mind of the debtor. They come to us sometimes and say, I did make my payment to the mortgage company.
I thought you just said, I thought you were arguing it's in the mind of the creditor, meaning that course of conduct. Well, now we're concerned with the mind of the debtor.
That's all, Judge, unless I misstated. The Kelly case is always about the mind of the debtor. And in the mind of the debtor is, I kept violating.
So long as the debtor thinks they're complying with the contract, that's all that matters?
And the debtor accepts the payment. That's what mattered to the lower court, because in cases, banks, sometimes mortgage companies, sometimes they keep it. And sometimes we have clients hand us the check back and say, they sent me back the check. That's a very different thing. And it was a very different thing for the lower court when they said in totality, this creditor received its money before time. And yes, there were words exchanged, but there's no evidence that the debtor agreed to have any one penny applied to $500,000. There was silence. Even Mr. Seifert said there was silence. And then they unilaterally said, oh, good, we'll keep getting this money and not sending it back. But then they did send one back, the last one.
Well, they sent that one back because the payment was conditioned on a final satisfaction of $100,000 debt as satisfaction for a $500,000 debt, which they were not willing to accept.
Which is the Pelley's position and the lower court's position was they should have, because under that one agreement, the only thing we have is one contract, not collections. It was $100,000 prior to March of 2019. And that's what happened. And that's why they sent it. Again, course of dealing. But there was a bunch of breaches, absolutely, from the beginning. And nothing happened. So in the mind of the creditor, as long as I keep paying, which the lower court found she did ahead of time in the end, and they can accept.
2 minutes to wrap up.
So in the end, this would be a very different argument, judges, your honors, if in fact the June 27 payment was returned. But that's not what happened, and obviously the subsequent ones. Because now we are talking about not only unilateral language that didn't impress the lower court, we're talking about conduct. They ratified the one and only agreement. There was never a second agreement. Each time they kept accepting monies to the total of $100,000, which that's what the agreement was for.
And they said that they were accepting it and putting it toward the final judgment after declaring a material breach of the settlement agreement.
But the debtor never agreed to that. And
Why does the debtor need to agree to that? The debtor already agreed to it when they signed a contract saying, conferring on the opposing party the right to declare a default in the event that they didn't cure after notice. What more does the debtor have to agree to?
The same contract that said you must pay by the 9th, and she never did. And yet, even the appellant admits that it wasn't terminated until June 27th from their end.
But it said at its option that they don't have to declare a default every time there's a late payment. If it says that at its option, it says, so how is that a waiver of their right to declare a default?
I didn't say it was a waiver of their right to declare the default. What I'm saying is this court should find that the conduct of the parties, they ratified that agreement every time they kept taking money after the 27th. And the argument was, well, no, because it wasn't exactly on the terms of the agreement. Payment.
Can I get something straight before I know time is short?
Yes, sir.
What is the course of conduct? Is the course of conduct the late payments prior to the payment that was decided that they decided to send a notice for and declare a default on? Or is the course of conduct the fact that after that time, when they had already made it very clear that they were considering that they expected the final judgment to be paid at $500,000, that any future payments would be applied to the $500,000, which is the course of conduct? That's why I said waiver. In other words, I'm just thinking that you were saying that the fact that they took late payments prior to their declaration of a default waived their right to declare declaration of default. But now you're saying, even though they already declared default, there's a post hoc waiver by accepting payments.
Let's give him a chance to answer because he is out of time. This is your last time on the clock.
Yes, Your Honor. The course of conduct was 100% of the monthly payments were not made timely prior to June 27th. And yet, prior to June 27th, nothing happened, meaning the unilateral termination of the contract did not happen. That's the course of dealing. And then the case that's cited in the brief, the Kelly Canfield case, says, well, that's the creditor is entitled to look at that. So what did she do when she looked at
Okay,
that?
I'm going to stop you because you're giving an answer that's like a run-on sentence. It's going to keep going. You're well out of time. I want to compliment you and thank you for your argument. I'm going to give Mr. Seifert a chance for his rebuttal. You asked for 3 minutes. Do you still want to hold yourself to 3 minutes? You can go up to 5. You're on mute. Mute button.
Yes, Your Honor.
There you go.
I hope not to use the 5. I hope to stick with the 3 just
Go
to
ahead.
move the
Come on.
court forward, certainly. It's been mentioned more than one time here that the appellees want the courts to rely upon the mind of the debtor. The mind of the debtor is not in evidence in this case. No testimony from the debtor. Nothing filed with the court could have. No testimony provided. What we have is, and what's been derided is just what's called more words, but that's what contracts are. They're words, and those words have meanings and they have importance. And the plain meaning of those words is black letter contract law, and they apply just as the court has indicated. So all the court could rely upon is the undisputed evidence filed with the court, which is really filed all by the appellant. Nothing was filed really in support of the motion to enforce a settlement agreement by the appellees, and certainly not any live testimony from any of the appellees with their thoughts about their how they perceived what was going on. Whether that's relevant or not, it's just simply not part of the record. The bottom line is this is a simple case that's been made to seem complicated. It's very direct and straightforward. We reasonably forbeared twice, enforced the 3rd time, 4th time declared a material breach, and thereafter all payments received were payments against the amended final judgment. We didn't have to ask for permission to keep them. We indicated what they were being allocated for. The appellees had an objection. They could either set something for hearing, send in an objection, or simply quit sending money. That's called ratification. When you keep sending money and people say what it's going for and you send it again and again and again. And we send accounting notices to be clear, envisioning this day, unfortunately. We thought it would end at the trial court level, but it's gone to the appellate level. So we made sure to document it, and we did all that we could do while accepting the funds, because not to take them, given what is indicated in the brief, they had rather taken the money, had a dinner, and filed for bankruptcy. There's no reason to give that money back, especially when we indicated what it was being allocated for without objection. So for the reasons and based upon the record, we would ask that the trial court's order enforcing the settlement agreement be reversed. We'd be allowed to pursue the amended final judgment.
And you kept it under 3. Thank you. Thank you both very much. Well argued. We're going to take a short break, maybe 10 minutes. That'll put us back here at 12:35, let's say. We'll be in recess.